Good morning, everyone. My name is Vinay Singh, and I'm working as an advocate at Bangalore. And today I'm going to talk about a topic freedom of expression and freedom of press. So, where is the difference, and what is actually freedom of press at this point of time? So now coming to the freedom of expression, we have in our Indian Constitution Article 19, which talks about a lot of freedoms: freedom of movement, freedom of expression, freedom of business, and other things. So definitely, other than in Constitution of India, it is also present in Article 19 of Universal Declaration of Human Rights, which talks about freedom of press, freedom of speech. It also gives that in case if you are able to articulate your opinion without any fear, you are able to articulate your opinion without any fear of punishment, without any fear of retaliation, without any fear of censorship, then you got actually the freedom of expression. Now freedom of expression is not an absolute right. It is subject to the reasonable restriction, which has been already decided by the Honorable Supreme Court in various time. Now when a minor community, a marginal community, when a person from a minority, when a person from a suppressed class, when a person from LGBT community is able to speak, express their opinion without any fear, we say that it is, they have got freedom of expression. So the purpose of this video is to give some information about various freedoms and freedom of expression relating to the freedom of press, and also talking a little bit more about the sedation laws, which controls the freedom of expression. So coming to the freedom of press, we have fundamental rights, as I told, and we have taken our fundamental rights from USA. In United States of America, freedom of press is considered to be a fundamental right. However, in India, it is freedom of press is not mentioned precisely, but it comes under freedom of expression. Freedom of expression, of course, is a fundamental right, but freedom of press is not considered to be a fundamental right at this point of time because of the current situation. Now giving more information about what is freedom of press, and what is the purpose of press is not only an information center where we go and get the information of our choice. It is also a watchdog. It controls. It is a fourth pillar of our democracy. It is nowhere different. It is nowhere different than legislature, lawmakers. It is nowhere different than the executive bodies. It is nowhere different from judiciary. It also gives some kind of strengthen. It gives power to our democracy, and it is very much required. Now there is a line: what is the subject to reasonable restriction, which we talk about. So your freedom, you got a free, as a press you got a freedom, but you should not talk certain things about the sovereignty, integrity of the nation. Your article or your show or your TV should not talk about the which breaches the security of a state, country. Also it should not be violating it to the public order and contempt of court, and a lot of other information. So talking about the public order, friendly relationship with foreign nations, and a lot of other things are there. But in India, for the purpose of documentation, we say that we have certain freedom given to the press, but in actual, most of the press are aligned themselves to the government. Whether whatever government is there, they are aligned to the government just to get benefit out of it. Most of the, if you as a media, you talk against the government, then definitely government will takes the revenge, and they will put you somewhere in the sedation laws and in various laws, so that you will be as a press, as a body who express their feelings, will be curbed. Now because you are a press, because your media, when they talk, people listen, and this list people, when they get listen, people get motivation from the article. People get motivation from the reports of the media. So government always against the such things, not always, but sometimes, yes, definitely they are against the, they don't want media to be, open media to be give any opinion about the democratic decisions in the country. So when we talk about freedom of press, freedom, we will come further on that. But when we talk about fundamental rights, which we have borrowed from USA, in USA we have freedom of press is a fundamental right, but in India it is not considered to be a fundamental right, but in custodial, in India we have a custodial death. We if a media reports about the custodial death, is it amount to a sedation? If uh, a media, if a press writes something against about the government, is it amount to sedation? We have a recent example of Hathras case. I'm not going to what is right and what is wrong, but what happens in Hathras case, which leads to file 22 sedition cases against the social workers, students, community, minor community people, marginal community people, and other various social workers. Why sedition case was required in India, where lot of almost all the big democratic country, they have removed this sedition, law of sedition from their laws, their acts. Why in India still we are using, these laws are being used as a tool, so that someone is trying to express the feeling, it can be handled by this law of sedition. Now in definitely we say that ignorance of law is there. We a lot of time we don't understand the situation consequences, and we just speak something. Now, and it is also said, there is a saying in law that ignorance of law is no excuse. Now in India we have almost 200, we have in almost 200 laws in every state enacted for their functioning. Also we have more than 2000 of laws only enacted under the Constitution of India by central government. Now is it practically possible for all the people to know about all the laws which is present at the land? It is practically not at all possible. So in this time, sometime if someone commits some kind of error because of the ignorance of law, does it amount to getting charged by the law of sedition sometime? This is definitely not, and that is not at all a purpose of democracy. So we have in India, in Indian Penal Code, we know that it is enacted in 1860, and that time we were under the British rule, and under section 124A, it is described it is described the definition of sedition, what is sedition, and how it is decided. But the question here is whether the law of sedition is being used for right purpose. No, there is another saying which is very much popular in the legal fraternity. It is called, sedition law is more abused than accused. It means then literally this is fact that only 1% of people get punishment, they get punished, and 99% of people got acquitted. Acquittal rate is 99% in law of sedition, and if this is the case, then we don't require the law of sedition in our nation. Now as I told, that there is no democratic country, big democratic country, which they have this law of sedition. Whoever had, they have already removed the law. And at this point of time, I don't personally believe that government should curtail the rights of the individual who wants to speak something, who wants to guide the government, who wants to give suggestion, who want to criticize. Let them criticize. That is the beauty of our country, and that is the beauty of any democratic country, that people are free to speak, free to convey their message to others. Now what is the outcome of this discussion? We were talking that definitely yes, we are freedom of expression, freedom of press is subject to the reasonable restriction, and we have to apply our mind. We have to be more responsible citizen. We have to be very much serious about this topic, and we should be very very careful when we talk. But it doesn't mean that when you want to criticize the government, when you want to talk against the policy of the government, when you want to say something wrong is happening in front of you, and maybe you are wrong and what is happening is right, but then also you are free to convey your message to others, you are free to talk to people, you are free to write, free to print, free to do whatever you want. That is also required in a good democratic country. Now there are certain cases, Keswanand Bharti cases, AK Gopalan cases, where time by time Honorable Supreme Court spoke lot of, given lot of guidelines, given lot of rulings, which refined and defined the law and Constitution of India. So we should also understand, there was a famous case which is in Bihar, where in 1962 it was held that law of sedation should not be used as a tool, and government should be very careful. And the Honorable Supreme Court had given four guidelines, four line of guidelines to fulfill. It's kind of a checklist. When it fulfills any of the criteria, then only it is considered to be a sedation. And but at present no state, no government is following the same thing. Most of the government just using this law to curtail, to stop, to suppress the feelings and the expressions of people, which is not at all required. So here there are two things. One is people, press should be given more power, press should be given freedom to write whatever they feel. It is criticizing government. I again say that criticizing government doesn't amount to criticizing the nation, or even criticizing nation sometimes it does not amount to the sedation. There is a certain criteria which if it fulfills, then only it is called sedation law or Desro law. Now with this I would like to end my discussion, and this is just to convey my feeling to others. I'm damn sure that not everyone will agree with my points, but here again we are talking about, I am expressing my feeling. You are also free to express your feeling. If somewhere it is wrong, I am ready to take your suggestion, and this is just a learning. This is not at all something which we are discussing. I wanted to express my feelings, which I thought right now. So I made this video. Thank you so much for your time. Have a nice day.